Yes, my talented and respected viewers, I'm excited today to present before you a video on a very good topic, on criminal topic, which is useful in the life of everybody. I wish that all the citizens of this country must live their life of dignity, and it is required genuine knowledge, preliminary knowledge of the law. And today's topic is very important. How much of information received from accused may be proved? These are the two lines, but are very important. I'll place into service Section 27 of Indian Evidence Act. I'll read out Section 27. Provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to confession or not, as relates distinctly to the fact thereby discovered, may be proved. Now, this section can be used by the police officer, or it can be misused by the intelligent police officer, and he can manage correction and punishment to the accused. On the other hand, a competent, well-experienced, intelligent defense advocate can manage acquittal of the accused. So this is the battle of wit between intelligent police officer and intelligent defense advocate. Let us watch this battle of wit. Now, the essential requirement of Section 27. The fact of which evidence is sought to be given must be relevant to the issue. Next, the facts must have been discovered. Next, the discovery must have been in consequence of some information received from the accused and not by the act of the accused. Next, the person giving the information must be an accused of any offence. Next, he must be in the custody of a police officer. Next, the discovery of fact in consequence of information received from an accused in custody must be deposed to. Next, thereupon only that portion of the information which relates distinctly or strictly to the fact discovered can be proved. Now, this section 27 of Evidence Act is based on doctrine of confirmation. Now, what is that doctrine of confirmation? The basic idea embedded in Section 27 Evidence Act is the doctrine of confirmation by subsequent events. The doctrine is founded on the principle that if any fact is discovered as a search made on the strength of any information obtained from a prisoner, such discovery is a guarantee that the information supplied by the prisoner is true. The information might be confessional or non-culpatory in nature. But if it results in discovery of a fact, if it results in discovery of fact, it becomes a reliable information. This is what the Supreme Court says in Canon of Judgments. Now, there are limitations for applying Evidence Act, Section 27. Section 27 prescribes two limitations for determining how much of the information received from the accused is provable against him. Number one, the information must be such as cause discovery of the fact. The fact must be in the consequence and the information the cause of discovery. Number two, the information must relate distinctly to the fact discovered. Both these conditions must be satisfied. Now, when these three terminology is used, first of all, fact. Fact in Section 27 means material or concrete fact capable of being perceived by our senses. It means psychological fact or mental fact is not included, only physical fact. Relate, what does it mean? The relate means to have reference to or to connect. And note distinctly means clearly or unmistakably or decidedly. only that portion of the information is provable which was the immediate or the proximate cause of the discovery of the fact. Anything which is not connected with the fact as its cause, or is connected with it not as immediate or direct cause, but as its remote cause, not permitted. It is not considered by the court. Now the gist of the law. Section 27 is not only a provision to Section 26, but cuts down the operation of Section 24 and 25 as well. So although confession by accused goes by, this is very important, listen to the wordings. Although a confession by accused caused by inducement, threat, or promise, or confession to the police, when the police custody is inadmissible. The ban imposed by the above section is lifted. Above section is 3526. If his statement contains any information leading to the discovery of a fact, that is property stolen, the weapon of crime, the dead body from some place of concealment, such discovery of fact is admissible, even though the information was obtained non-voluntary. What is the meaning of this? East of the law. अगर पुलिस ने उसको कोई लालच दी है, इंड्यूसमेंट किया है, कोई धमकी दी है, प्रॉमिस दिया है, कन्फेशन करा है, तो 25-26 एविडेंस से बोलता है वो वैलिड नहीं है। मगर यहाँ एक प्रोविजन है जिसका फायदा पुलिस ऑफिसर लेता है और एक उसका फंसाता है। The ban imposed by the above section lifted if his statement contains, समझदार का कंटेन, प्रिजनर का कंटेन, इंफॉर्मेशन लीडिंग टू द डिस्कवरी ऑफ फैक्ट। अगर वो इंफॉर्मेशन से कोई फैक्ट पुलिस ऑफिसर के हाथ में आता है, कोई फैक्ट मीन्स चोरी का माल, किसी मर्डर किया तो डेड बॉडी, अगर यह मिलता है तो वेदर इट इज वॉलंटरी, स्वेच्छा से इंफॉर्मेशन दिया है या धमकी से दिया है, कुछ भी कैसे भी दिया है, it is valid. So police officer takes the benefit of this. It is to be noted that mere discovery of fact by means of information from accused is not relevant unless it is further shown by other evidence that the article discovery is in some way connected with the offence charge and the accused. कुछ डिस्कवरी मिल गया, चप्पू मिल गया, तो इससे कुछ होता नहीं, तो मैंने बोला ये चप्पू है, ठीक है, क्या होता है, मगर वो चप्पू से आदमी को मारा है, उससे जो कनेक्टेड मैटर है, कनेक्टिंग एविडेंस, अगर वो मिल जाता है, then he can be punished. Now, this is very important point. How the statement of the accused can be reduced to writing, how it should be recorded. There are certain conditions, and investigating officer has to follow it. If it doesn't follow, then that information is not valid. Number one, statement made by accused to police officers which are or may be provable under section 27, वो कैसा होना चाहिए? Clearly and carefully recorded. Second, they should be recorded with the first person, first pronoun, means I. I have seen this, I have murdered this man. I, first person. They should be recorded in the actual words of the accused. तमद्दार जो शब्द में बोलता है, उसकी जो भाषा में बोलता है, वर्नाक्युलर लैंग्वेज, उसमें रिकॉर्ड किया होना है। गुजरात में कह रहे कि बार बार बोली बदला है। A man from Saurashtra, a man from Southwest, a man from Mehsana, a man from rural areas, a man from urban city like Ahmedabad or Baroda, their Gujarati is different. These are different words. For example, Kamcho, Chamcho, very different, meaning is same. So it should be recorded in the vernacular language of the accused. And it should be recorded as he says. वो जैसा बोलता है वही शब्द में लिखने का. You should not make a paragraph. It should not be paraphrased, not like essay. What is the duty of the judge? No judge should allow the word. जब आयो आता है विटनेस बॉक्स में, सब साक्षी को एग्जामिन करने के बाद वो अपना एविडेंस देने के लिए वो टाइम जज को क्या देखने को होता है? No judge should allow the word more to be deposed to by the police than is absolutely necessary to show how the fact discovered is connected with the accused. ये जो फैक्ट डिस्कवर किया है, फैक्ट मीन्स चप्पू, लाकड़ी, जो पिस्तौल जो भी डिस्कवर किया है, वो आत्महत्या ने गुनाह किया है, इसके साथ किस तरह कनेक्टेड है? We should talk about this, not any other things. Practice of the police recording wholesale confirmation, running to several pages, incorporating most incriminating statement against co-accused and getting it attested by witnesses, it is condemned. वो पुलिस ऑफिसर साथ में जो को-accused होता है, उसका स्टेटमेंट लिखता है, लंबा लंबा ऐसा के बारे लिखता है, और नीचे साक्षी के साइन भी लेता है, witnesses. That is condemned, not allowed, not only allowed, but it is condemned. This should not be done. Disclosure statement pointing out the place of occurrence, which are already known to the police, is not admissible. What is the value of disclosure statement? What is important is discovery of material, object, and disclosure of accused. But such disclosure alone would not automatically lead to conclusion that the offense was also committed by him. वो information था, इसका मतलब नहीं कि उसने गुनाह किया है. He might have got information from any source. Thereafter, burden lies on the prosecution to establish a close link between discovery of material object and its use in the commission of the offense. What is admissible under Section 27 is information relating to discovery and not any opinion formed on it by prosecution. Prosecution कोई भी रुपया दे सकता है, सब किसने ये चप्पा से मारा, not that. Give us connecting evidence. Suspicion, however strong, cannot take the character of proof. Now let us talk about co-accused. I place into service Section 30 of Evidence Act for the disclosure statement of an accused. Whether it can be considered as evidence against accused, main accused? No. Why? It is not real evidence as defined in Section 3 of Indian Evidence Act. क्यों evidence नहीं है? What are the reasons? Law is a science. When it is presented, it is an art. So there are scientific reasons for not believing the disclosure statement of co-accused. कोई भी फंसाने के लिए बोल सकता है. Number one, that statement is not an oath. वो सदन में पुराने दे रहा है. Now second is, it is not given in the presence of accused. The police officer statement लेता है, accused, main accused हाजिर नहीं होता है. Not given in the presence of accused. And the third, it is not tested on the cross-examination. These are the three things. So, court will not believe him. It will be discarded. There could be no connection without the fullest and strongest corroboration on material particulars. The conclusion of co-accused cannot be treated as substantive evidence. And without substantive evidence, there cannot be punishment. In the absence of substantive evidence, corroborative evidence has got no value. It is of no worth. So in criminal trials, there are no scope for applying the principle of moral conviction or grave suspicion. कितना भी बड़ा गुनाह किया हो, मगर अगर substantive evidence नहीं है, तो moral ground पे और suspicion पे किसी को भी सजा नहीं दे सकता. In order to sustain the guilt of such accused, the recovery must be unimpeachable and not be shrouded elements of doubt. Factors which aid engaging. Evidence Act. Now this is the last but not least. Misuse of Section 27 by the police officer. Police officer किस तरह misuse कर सकता है? This is not an exhaustive list. There are some examples only. The list can go on. There can be a long list. But I am citing a few examples, few points. The protection afforded by the under some provisions of Section 25-26 is sought to be whittled down by the police by their ingenuity in manipulating the record of the information given by the accused in the case diary in such a manner as to make it appear that it led to the discovery of some facts, although the police might have made such discovery from other sources. पुलिस को कहीं से भी जानकारी मिली हो, मगर वो कई ऑर्गेनाइजेशन तरीके से तमद्दा नहीं है. So that is misuse. A fact previously discovered by the police from other sources cannot be regarded as discovery. दूसरों से मालूम किया discovery, it cannot be described as discovery. But the same information received again from accused with the object of making his statement admissible. Any statement in order to be admissible must be made before and not after the discovery. This is very important. It has been observed that it has become the normal device of the investigation agency to turn an ordinary recovery into the discovery. A device sometimes adopted by the police is to stage a scene and take the accused to the place where the things discovered lay buried or hidden, and require him to make a search for them at the spot indicated by the accused, or sometimes they have been made by him about the so-called discoveries are recorded. When the person is subsequently taken into custody, this is very important, and becomes an accused after committing a crime, meets a police officer, or voluntarily goes to him or to the police station and states the circumstances of the crime which leads to the discovery of the dead body, weapon, or any material fact in consequence of the information that was received from him. क्या क्या बोलता है कि एक आदमी ने मर्डर कर दिया और सीधा पुलिस स्टेशन जाता है, पुलिस अफसर को बताता है कि साहब मैंने किया है, मगर ये समझो कि मैंने किया है. बोला चलो मैं दिखाता हूँ मर्डर कहाँ किया है, प्लेस ऑफ ऑकरेंस, बॉडी कहाँ है, कपड़े कहाँ हैं. That is not discovery. It is not relevant. This information which is otherwise admissible becomes inadmissible under Section 27 of Evidence Act if the information did come from the person in the custody of the police officer. So, these are the main provisions of Section 27 of Indian Evidence Act. One has to be very careful. One must know about this. Hope you have enjoyed this video and you have got some information, and together let us cultivate the life of wisdom. See you in the next video. Thank you. Thank you. And then I am going to request all of you in two categories. Those who are new to our video should subscribe, like it and share it. Those who are not new but so far not subscribed, then please subscribe it. And those who are subscribed, don't repeat it. You require only once to subscribe, but you can like it, you can share it. That's all. Thank you very much. Thank you.